chance there is that the landlord is going to rent that flat to a person with a passport way before they're going to go through the process of checking the Polish lad's immigration status. The right to rent scheme is already in limbo because judges have found episodes like this already occur with other less complicated forms of proof. And what if the digital system crashes altogether at a crucial moment? It's happened already. Again, the Home Office is making decisions against the interests of EU citizens. So that is why Amendment 5 calls for a physical document to be provided. Let me acknowledge one good decision that the Government has made, and I like to be fair, and that was to open the settled status scheme to a broader category of citizens than strictly required by the withdrawal agreement. Amendment 6 seeks to cement that into primary legislation rather than leaving it to the whims of an immigration minister to do away with at the drop of a hat by changing immigration rules. Again, the official opposition's new Clause 5 does the same. But a third disappointing choice that the Government has made regards the make-up of the Independent Monitoring Authority. That's the body tasked with ensuring citizens' rights under the agreement are properly protected. The withdrawal agreement gives broad discretion as to how that board should be made up. Now, given the torrid time EU citizens are enduring, the last thing they want to see are provisions that mean that the person appointing the members of the IMA is a person who has ignored all their other concerns and broken the key commitment that she made to them during the referendum, and that is, of course, the Home Secretary. Yes, there are other provisions that are designed to create a degree of independence for the IMA, but in advance of the creation of the IMA, it is the Chief Inspector of Borders and Immigration that has been monitoring the settled status scheme and has prepared reports and recommendations about it. So I'd say that makes him a strong candidate for knowing what skills are required and are needed for the Independent Monitoring Authority. But there are other alternative independent people who do that task and give EU citizens much more faith in the process. Additionally, in Amendment 52, we seek to strengthen the role of devolved administrations in the process of appointing those IMA members being selected because of their knowledge of conditions in devolved areas. Turning to the issue of appeals, it is again positive that the bill makes provision for a right of appeal against settled status decisions, but not that it does so only by way of regulations or immigration rules. There should be a statutory right of appeal in this primary legislation. There are significant rights. These are significant rights not to be toyed with on the whim of a minister. So again, we support parties who have tabled amendments to put the appeal right in the bill directly. And in Amendment 7, we challenge the Government on why it is giving ministers the right to make provisions about judicial reviews of certain citizens' rights immigration decisions. This, to me, seems unprecedented, Sir George, and if the Minister can provide another example of where such a power has been granted, I would be very grateful to hear about it. There is a huge concern about what this Government wants to do with judicial oversight of decisions that it makes, and I hope that this is not an early example of Government attempts to curtail judicial oversight of very significant and sensitive immigration powers. Finally, Sir George, I turn to the issues of registration of British citizenship. Another scandal that has developed on the watch of successive Conservative Home Secretaries, negligently conflating naturalisation with registration. After the British Nationality Act 1981 came into force, many children and young people who would automatically have been British through birth here instead were given a statutory right to register as British if they met certain criteria, such as living in the country for a certain period or their parents becoming settled or British. These criteria reflect the fact that for these children and young people, the UK is their true home. De facto, they are British, and therefore they should legally be entitled to have British citizenship. As a Conservative Minister of State put it when introducing the relevant provisions in 1981, he said, "It is extremely important that those who grow up in this country should have as strong a sense of security as possible." This is not the same as naturalisation, where the law gives the Secretary of State discretion in relation to people who have chosen to make the UK their home. Yet the Home Secretary charges children to register as if the two things were equivalent. Even though the administrative cost to the Home Office of registration is around £370, the Home Office has been charging over £1,000 for several years, something which the now Chancellor acknowledged was a huge sum of money when he was asked about it at the Home Affairs Select Committee. Now imagine, if you would, Sir George, anyone in this chamber been asked by an official for £1,000 before their child could be confirmed as British and could exercise their rights as British citizens. It would be deemed outrageous and totally unacceptable to every single person in this chamber. And it is similarly outrageous that the Home Office is inflicting that fate on other children who are just as entitled to their British citizenship.
He's making an excellent point. I'm glad to see him raising this issue. And quite often I get families at my surgeries who can't afford to have their children registered. They might register themselves because they need to work or they need to travel, but they can't afford to pay for their children. And with the decision of the courts on this issue, has he any view on whether or not that people ought to be issued with refunds for the children they've already paid for that the courts have ruled unlawful?
I would fully support that decision, and I'll come to the issue of the court case in a moment. Indeed, one other example that I found in certain surgery cases is parents have to choose which child it is that's going to become the British citizen because they cannot afford to pay to two, so they pay for two or three. So they have to pick which child to benefit from citizenship. It's a really, really appalling and cruel game. So it is welcome, as my friend has pointed out, that the fees have been found unlawful in the High Court because they do not properly take into account the best interests of children. And I pay tribute to the Project for Registration of Children as British Citizens, Amnesty International and others for their work on that case. Now, instead of appealing against that decision, the Home Office should listen to the reasoned arguments and stop this absolute scandal. And among the victims of this scandal are many EU and EEA nationals. For example, a young Belgian girl born in the UK to Belgian parents just after they moved here and before they were settled. She becomes entitled to British citizenship automatically after 10 years, or if the parents become UK citizens or settled themselves. But she or her family quite simply may not be able to afford the £1,000 fee. So she, along with many, many others, will be forced to register under the settlement scheme when they have a far stronger right to citizenship. As a project for registration of children as British citizens, and Amnesty pointed out in a letter to the Minister's predecessor, children and young people in the care system are especially at risk. There are many things, Sir George, that need to be done to allow children and young people to access their rights to British citizenship. But one key part of it is ensuring that all who have that right through registration can afford it. And that is why new clause 18 sets out to limit the fee that can be charged to the administrative cost of that and to provide for fee exemptions and waivers in appropriate circumstances. I don't want this to be limited to EU citizens. It has to because of the scope of the bill, but there's a far bigger job of work to be done in ensuring that this is done right across the board. And as my honourable friend points out, we should be looking to reimburse those who have had to break the bank or take loans or do whatever else simply so that their children can become the British citizens or register their right to British citizenship that they're entitled to under statutes passed in this place. It seems a simple matter of justice to me. I can't understand how any government or MP would want to continue to price de facto British citizens out of the legal British citizenship that they are entitled to, and that is why new clause 18 should be put to a vote this evening, Sir George. Finally, in conclusion, many EU citizens are having an incredibly difficult time of it, and that is to put it mildly. They have been hurt again by the lazy rhetoric coming from the party opposite during the election about the cost of benefit payments to EU migrants and about the Prime Minister's remarks on EU citizens daring to treat the UK like their own country. Instead of occasional platitudes in this chamber, we need consistent and vocal support for EU nationals, and more than that, we need action, not words, and these amendments and new clauses are exactly the action that is needed to improve their lives.
The question is that Amendment 5 be made. Brandon Lewis.
Thank you. Thank you, Mr. Chairman. It's now been over 3 years since the referendum, and we're here today because the Conservative Party can finally break the deadlock and ensure that there is no more delay. This bill means that the UK will leave the EU on the 31st of January, delivering on our pledge to get Brexit done. Our Prime Minister, standing right here, laid out a powerful vision for a rejuvenated, forward-looking, optimistic United Kingdom. This bill will allow us to unite the whole country and take advantage of those opportunities that lay ahead for us. And throughout the negotiations, our first priority has been to safeguard the rights of EU citizens, those who have built their lives here and contributed to the UK. The clauses laid out in the citizens' rights part of the bill are essential to implement the withdrawal agreement so that EU citizens' rights to live, work, study and access benefits in the UK are protected. We have delivered on this commitment, and this bill provides certainty to EU citizens and their family members who are covered by our implementation of the withdrawal agreement. The citizens' rights clauses 7 to 17 of this bill include the provisions to implement technical aspects of the withdrawal agreement. This will provide for a grace period for EU settlement scheme applications. Frontier workers, restrictions of rights of entry and residence, appeals, recognition of professional qualifications, social security coordination and equal treatment. The bill also implements the EEA-EFTA separation agreement and Swiss citizens' rights agreement, providing EEA, EFTA and Swiss nationals with certainty. And unless I make further distinction, just for colleagues' reference, I will refer to this entire group as EU citizens going forward. Once we leave the EU, and after the implementation period, we will end free movement. And turning to the specific clauses, Clause 7 does allow ministers to set a deadline for applications to the scheme, and it enables the government to preserve the rights of EU citizens during that grace period. It also means that we can maintain the same protections for those with a pending application or appeal at the end of the grace period. Mr. Chairman, I would urge and ask honourable members to withdraw new clauses 5, 18 and 33, as well as amendments 5, 6 and 27 to this clause, which put the success of the EU settlement scheme in jeopardy. If we remove the need to apply for status or to put in place a declaratory system, provide for physical documents, lock the eligibility criteria and remove the deadline, it could actually undermine our ability to give EU citizens the certainty that we have promised and are determined to deliver. And I will be very clear with members as well. The EU settlement scheme itself is already up and running. It's designed to be quick and easy for applicants, and it's working. Just for members' information, the latest figures show that over 2.8 million applications have now been received, and nearly 2.5 million people have been granted status. The scheme is a success. Sorry, I'll have to give way.
I'm grateful to the Minister for giving way. As you will know, I questioned the Prime Minister on this on the 25th of July. I reminded him that during the referendum, the Prime Minister personally promised that no EU citizen living in the UK would be treated any less favourably as a result of leaving the European Union. On 25th of July, I asked the Prime Minister if he would now guarantee the right to healthcare, to pension rights, the right to leave and return, the right to bring over family, the right to vote and all the other rights currently enjoyed by EU citizens. The Prime Minister at the dispatch box told me and told this House that the government were giving those guarantees unilaterally. Could the Minister now tell me where in this bill the right to pensions, the right to healthcare, the right to bring family members over at some time in the future, which clauses of this bill make good on those promises from the Prime Minister? Because if they're not in this bill, then the Prime Minister has stood at that dispatch box and made promises that the government has no intention of keeping.
I just think it's worth drawing people's attention to the fact that interventions should be brief and to the point. I'm not necessarily saying the honourable gentleman's wasn't, but for further reference, I think that advice should be taken. Minister.
Chairman, and look, I would say to the honourable gentleman, as my honourable friends and right honourable friends will outline as well, we are, in working with our colleagues around Europe, we have had, I have to say, all our colleagues around Europe and our friends around Europe are very, very happy with the scheme. In fact, our scheme is far more generous, as I'll come to in a few moments, than many of the countries around Europe offer to UK citizens. I hope that will change. But this programme, and I'll come to some specifics in further clauses, sticking to clauses that are before us today, is something that does deliver. And it's delivering a scheme that, as I say, with over 2.8 million applications already and some nearly 2.5 million already being granted, is a success in a moment. And the EU citizens in the UK also have until the end of June 2021 to apply. Happy to give way.
Can you tell me how many individuals have applied? They may have made several applications, but more importantly, does he dispute my estimate that there will be hundreds of thousands of EU citizens who will fail to apply in time? Has the Home Office made that assessment?
Well, actually, I do disagree with the honourable gentleman. In fact, I disagree, as I'll go on to say, quite a lot of what he's just said when he was on his feet a few moments ago, where he gave actually some very clear, I would say, misrepresentation of what is happening with this system. When you've already got over 2.8 million people applying and almost nearly 2.5 million have already been granted, I think that does show, for a scheme that has not been running for a year and still has at least a year and a half to run, It is working. And I would also go further to the second part of his question and just remind him and let other colleagues who aren't aware of this know that not only have we said that even after June 2021, if somebody has a good, reasonable reason for not applying earlier, we will still process their EU settled status, but we are specifically doing the work with groups around the country to reach the most vulnerable people, whether it's road shows, whether it's work online, whether it's the phone system, the phone centre that we have that's working round the clock 7 days a week to be able to take any queries that people have got. Working with voluntary groups around the country, some £9 million that we have put in to work with those groups to reach all of these people. So yes, I do disagree with him in the sense that I do think we will get to these people. And I will just say, in a moment, I will give way. If citizens do not apply through the EU settlement scheme, it may prove difficult to distinguish those EU citizens from those who arrive after the end of the implementation period. The honourable gentleman, in his words earlier, ignored that fact completely. It is essential that they have the evidence that they need to demonstrate their rights here in the UK. Such an approach, no, not at the moment, such an approach could also lead to EU citizens who have not applied for documentation, suffering the inadvertent discrimination compared to those who have. That is exactly what happened to the Windrush generation, and we as a government are adamant that we must avoid a repeat of that dreadful situation. Yes, absolutely.
Mentions the Windrush generation, he will surely recognise that many of the amendments that are being put down in this relate to concerns that myself, the Honourable Member and others raised during sessions of the Home Affairs Committee where we examined the EU settlement scheme and of course the Windrush scandal, and there's not some sort of malign intent by these are to ensure that people have their rights and they're able to exercise them. What lessons has he learned from the Windrush scandal and indeed the evidence that was taken for our committee?
Well, I think the honourable gentleman makes a good point. In fact, I think it is clear we all want to ensure, as I've just said, that we avoid the problems that happen with the Windrush generation. One of the key issues, I'm going to finish answering the first intervention before I consider taking any others on this issue. And I have to say on that point, part of the challenge and the problem with a declaratory scheme is it exactly leads into the problems of Windrush. This scheme means that people have evidence of their rights. That means in the future that can not be contestable, and we avoid that problem in the first place. And moreover, this scheme is already more generous in its scope than the agreements themselves actually require, which the honourable gentleman did outline in his remarks. For example, there are some people who do not meet all of the current requirements of free movement law and so are outside the scope of the agreements. As a matter of domestic policy, we have decided nevertheless that people like that should be in scope of the EU settlement scheme and so have granted residence rights. And on physical documentation, I'll go a bit further. We're developing a new border and immigration system that is digital by default for all migrants, not just EU citizens. This is being rolled out incrementally, and over time, we intend to replace all physical and paper-based documents, which can be lost or, of course, stolen. Eventually, all migrants, in one moment. Eventually, all migrants, not just those from the EU, but also the rest of the world, will only have digital status. So this amendment would impede our ability to deliver this improved, equal, fair digital status. Yes, I have to give way.
Does a minister not understand that getting to the end of the process of settled status at the moment and yet being told that your email is meaningless and you will not have a document is not reassuring to people? Part of Windrush were because the Home Office destroyed records. So people who are depending on the Home Office to keep a digital record are actually naturally pretty nervous. I think they would keep their records quite safe at home. And the other one, a declaratory system does not prevent having a registration. You register people, but you automatically are saying they have the right. This is an application. People are being turned down or given pre-settled status. It's not the same.
There's a couple of things what the lady has said. I think it is just important to, as I say, clarify some of the misrepresentations. Look, the argument she's just made argues for and against her colleagues' earlier comments, because we want to make sure that people do have that status. That digital status means it is there forever. It means that employers, landlords, anybody can access that in the future. It's not reliant on somebody keeping any documentation or not having it stolen, etc. And I would just say to her, in terms of her comments about the process, it is a very fast, quick, easy process. It's one that, I'll just finish the point, while she's saying for settlement position it's not for everybody, it's a process that takes 5 to 10 minutes online, the same way as it would for any of us who are renewing a driving licence or a passport. And I would say to her, she should just be aware that as of the last set of official figures, there have only been 2 people actively refused settled status, both of which on serious criminality grounds. And I stand by this country's right to protect the security and safety of people in this country by refusing people with a serious criminal record. Pre-settled status is only granted to people who have not been living in the country for 5 years at that point. Up until that point, and I will come back to the process around that in a moment, anybody who's lived in the country for 5 years or more, and we help them the way they can evidence that, is entitled to full settled status. And protections for those who do not apply by the June... Now, I'm just going to finish my earlier point. Protections for those who do not apply by the June 2021 deadline are already built into the agreements, ensuring that there will be no cliff edge for the vulnerable people unable to make an application due to circumstances beyond their control. As with all aspects of the EU settlement scheme, we will adopt a very flexible and pragmatic approach and exercise discretion in applicants' favour. Mr Chairman, I therefore do urge honourable members to withdraw these amendments, but I'll take the honourable lady's intervention.
Accurate. You know, I have a constituent who had a national insurance number card, which aren't even issued anymore, who was only given pre-settled status. Yeah. That constituent was able to prove that they would be here. Everything that they had put in was correct, but yet they got pre-settled status. How many more people have been given that?
40%.
As I said, anybody who has lived in the country for 5 years or more is entitled to settled status. I have to say, I'm very happy if the honourable lady would listen to the answer. If honourable members have got individual cases where somebody's been granted pre-settled status that they feel should have had full settled status, I will personally look at those cases. Every case that has come forward so far has turned out to be an issue where somebody in one case hadn't actually even applied for settled status at all and had gone for an entirely different system, and in other cases hadn't been able to put evidence forward. But our teams do work with people. That's why we do the roadshows, so they can actually work with people to ensure that anything that they can provide that gives evidence of them being in this country for more than 5 years allows them to be granted settled status. And with nearly 2.5 million already being granted out of 2.8 million applications, I think that highlights the success. No, I'm not going to give away on that point any further. Mr Chairman, Clause 8 enables the government to protect frontier workers and means we can establish a registration scheme providing certainty to frontier workers about their rights going forward. Clauses 9 and 10 go hand in hand, enabling us to continue to apply EU deportation thresholds when assessing conduct committed before the end of the implementation period, for the purposes of restricting a person's right to enter or reside here in the UK. Conduct committed after the end of the implementation period will be assessed according to the UK rules on criminality and behaviour non-conducive to the public good. This creates a fair and even system for all, which does not benefit any foreign nationals over others. Clause 11 provides a power to put in place various rights of appeal in connection with citizens' rights, immigration decisions, including refusals under the EU settlement scheme, which are an essential and an important part of our commitments. Mr Chairman, I would ask honourable members to withdraw amendments 3, 2, 20, 21, 7 to this clause and new clause 34. They are unnecessary. Thanks to the power contained in clause 11 of this bill, EU citizens who are appealing a decision on residence will be able to do so under the EU settlement scheme. Individuals who have been granted pre-settled status, who believe they should have been granted settled status, can also appeal. These amendments would also actually potentially do damage. The situations requiring a right of appeal under the agreements are numerous, and the applications of existing rules relating to appeal rights are complex. Putting a right of appeal on the face of the bill would mean that none of this detail can be properly reflected. And these amendments would make it harder for EU citizens to appeal against an exclusion decision. They would actually remove our ability to provide EU citizens with access to the Special Appeals Immigration Commission when challenging an exclusion decision through judicial review. It would also prevent the government from treating EU citizens in the same way as third country nationals when it comes to removals during an appeal process. Furthermore, these amendments create a perverse incentive for individuals to launch appeals and would mean that people who have applications that have absolutely no chance of succeeding would be able to access social security benefits. I'm concerned that this would open our immigration system to potential benefits abuse, and that is something we should not allow. I hope what I have said reassures the honourable member that these amendments are not only undesirable but are unnecessary, and so I do urge them to be withdrawn. Clause 12 provides a power to amend the statute book, protecting existing decisions on the recognition of professional qualifications and ensuring outstanding applications for recognition can be completed. This lifelong recognition of qualifications will provide certainty to professionals such as nurses, vets and lawyers who provide crucial services to us all. The power in Clause 13 enables the government to maintain our statute book in accordance with the social security coordination provisions. This will protect areas such as access to pensions, benefits and healthcare cover for those who have moved between the UK and the EU before the end of the implementation period. Clause 14 provides a similar power for maintaining the statute book to make sure that rights of equal treatment and non-discrimination are protected in the future. For example, making sure EU citizens resident before the end of the implementation period continue to access benefits and services on the same basis as they do now. Clause 15 establishes the Independent Monitoring Authority for the withdrawal and EEA-EFTA separation agreements on citizens' rights. As Schedule 2 makes provisions about its constitution and functions. It will be fully independent, and it will have significant powers to be able to receive complaints and to conduct inquiries. It will also have the power to bring legal action against the government and public authorities. And work is well underway already in the Ministry of Justice to set up this new organisation. Mr Chairman, I would urge honourable members to withdraw amendments 22, 23 and 37. The first two are unnecessary, as non-executive appointments to the board will be made under the well-established principles of public appointments, in accordance with the Governance Code on Public Appointments. And the Secretary of State will also be under a statutory duty to have regard to the need to protect operational independence of the IMA. Clause 16 contains supplementary provisions, for example, to prevent any overlapping conferred powers affecting the extent of any power of a devolved authority. And Clause 17 provides the necessary definitions for terms used in this part of the bill. Mr Chairman, I would also urge honourable members to withdraw new Clause 18 to remove the fee for citizenship for EU citizens. It could lead to discrimination by nationality by giving EU citizens preferential fees for citizenship. It would also, It would also undermine the legislative structure that is already in place, which not only sets fees but provides for specific fee exceptions. Give way to the Honourable Gentleman.
Exactly why there is a sub-clause in there that allows the ministers to extend the reduced fee and the waiver scheme to everybody else as well. So it's entirely within the minister's gift to make sure that discrimination does not arise. What is discriminatory is a horrendous fee which prohibits some kids from getting the British nationality that they are just as entitled to as the children of everybody in this place.
Yeah. Well, look, I have to say, looking at the way the amendment is drafted, we do think it would be discriminatory by nationality because, as I say, it would give EU citizens preferential fees for citizenship on the face of the bill. But as I would have hoped that the next sentence I issued would have negated the need for his intervention as it happens, because what I actually then went on to say was it would also undermine that legislative structure that is already in place. This bill is not the place that sets fees. That is done in specific with specific fee exceptions as well provisions in different legislation. Mr Chairman, the clauses laid out in the citizens' rights part of the bill honour our obligation to EU citizens who are living in the UK and ensure that they have the certainty that they need as our country moves forward. I will also be very frank with colleagues here today. It is disappointing that not all European countries have provided the same assurances for British nationals living in the EU. And this is something that we hope will change and we will continue to work towards for our citizens. This government has always put citizens' rights first and foremost and will continue to do so. EU citizens are our friends, they're our family members, they're our colleagues. They have made and continue to make a hugely important contribution to our country, our economy, our communities, our society. We want them to stay. This bill will ensure that we can deliver that unequivocal guarantee both now and in the future.
Paul Blomfield.
Thank you, Sir George. And I rise to speak on new clause 5 on the system for providing settled status, on which we will be seeking a vote, and on amendments 2, 3, 20 and 21 on the right of appeal, as well as amendment 37 on the Independent Monitoring Authority. And I have to say that I regret the Minister's combative response to the Honourable Member for Cumbernauld, Kilsyth and Kirkintilloch East, who I thought made a typically thoughtful and considered contribution, which reflects not divisions across the House, because when these issues have been debated previously in Parliament, there has been considerable concern on both sides about the consequences of getting this wrong. And if we do, it will have not only a significant impact on EU citizens within the UK and Brits in Europe, but also, frankly, on our caseload as members of Parliament. So I do believe that there is the possibility of reaching agreement around some of these issues, and it's in that kind of mood, that spirit, that I'm proposing our amendments. Let me start with new clause 5. Now, the Minister said that providing certainty for EU citizens was central to the government's agenda, and the Prime Minister said that, and I quote, "Under this government, EU citizens will have the absolute certainty for the right to live and remain." Now that seems clear, but the reality of applying for settled status is different. It's a constitutive system in which EU citizens only acquire settled status or pre-settled status by successfully applying for their right to live and work in the UK post-Brexit. New Clause 5 seeks to avoid that by making the scheme declaratory, meaning that EU citizens and family members who meet the eligibility criteria would automatically have the right to continue to live and work in the UK and would simply need to register for the purpose of proving their status. Now, we believe that our approach will avoid a repeat of Windrush, and the Minister suggested that their objective was to avoid that, and the declaratory system could encourage a repeat of the Windrush situation. So let me just comment briefly on that. I mean, the Windrush scandal was caused by a number of factors. It was the legal environment changing around people who'd lived here for decades. It was the 2012 introduction of the hostile environment. It was a lack of record keeping. It was a lack of record keeping by the Home Office, by this government, and when we were in power. I'm not trying to score party points here. And it was by Home Office staff being incentivised by targets and bonuses to reach deportation targets. But for the Windrush victims, this is crucial, for the Windrush victims, there was at least the legal safety net thanks to the Immigration Act of 1971. So they could seek recourse against the treatment that they received. Now, what the government are saying is that making the EU settlement scheme declaratory would create a second Windrush. They are perversely blaming the scandal, and it was a scandal, and the Minister recognises that, blaming it on that safety net. And that's a fundamental misunderstanding. They're saying that the way you avoid Windrush is by removing the safety net that the Windrush victims faced. Now, no system is going to get 100% of those eligible to apply. And I recognise the points that the Minister was making about the efforts that the government has been taking to ensure as many apply as possible. And I take his point that 2.8 million have already done so, and I'm sure that many more will by the deadline of June 2021. But not everybody. And the government doesn't even have a target for how many people they think should be eligible to apply. Now, if only 3%, that's not beyond the bounds of possibility in any way at all. I mean, I've talked to so many EU citizens who, despite all the government's publicity efforts, are unaware that the rights that they've enjoyed for 30 years need to be applied for. And I've had to explain to them about how to apply for settled status. So if only 3% of the estimated 3.5 million EU nationals living in Britain fail to apply, that will leave 100,000 people facing the hostile environment and facing possible deportation. Now, the government have recognised this, the Minister has himself recognised it. He said in an interview with the German newspaper Die Welt, and I quote, If EU citizens have not registered by the deadline for settled status, without an adequate justification, the immigration rules will apply. When pressed on whether that would mean deportation, he said, quote, theoretically, yes, we will apply the rules. The possibility of people who we describe as our neighbours, our friends, taxpayers, our colleagues, being deported exists while we pursue the same approach to settled status as the government are now. It's not too late to correct course, and in our view, and the view of others moving similar amendments, a declaratory system is the only way to prevent hundreds of thousands of people potentially being criminalised and potentially being deported. Under a declaratory scheme, if somebody doesn't register for settled status before June 2021, they will not lose rights. They'll simply need to register for the government to provide them with the proof of that status. I will.
For the speech that he's making. On that point, does he agree with me that the Minister is completely wrong to think that a declaratory system means that fewer people will apply? After June of next year, people will still have every incentive to apply for the settlement scheme because they will need that proof in order to avoid the hostile environment, to access NHS, to access employment and to access all of the other entitlements in this country.
Yeah, my honourable friend is absolutely right. There'll be every incentive to apply because without the proof, they won't be able to exercise the rights. What we're simply seeking to ensure with this new clause is that they don't lose their rights. And the approach that we're suggesting is explicitly allowed under the withdrawal agreement. The government had a choice about what kind of system they would implement, and in our view, they chose wrong. And we need to remember that this isn't just about EU citizens in the UK. The largest national group affected by Brexit are the 1.2 million British citizens in Europe. And the EU and individual member states, not all have met our expectations either, but have been clear that rights granted to UK citizens will be based on reciprocity. So the Minister's right to want to see other countries stepping up to the mark, but that won't be assisted if we reduce rights of citizens within the UK, because that will risk a reduction of rights of citizens across the EU 27. So a declaratory scheme for EU citizens will not only be good for those here, but will be good for UK citizens living in Europe. Let me move on to another aspect of the problems with the EU settlement scheme. And the Minister said 2.8 million have applied, and he went on to sort of unintentionally give the wrong impression, I'm sure, about the granting of status, because he said 2.5 million have been granted status. Correct, but not the status they applied for. The most recent statistics show that almost half of the applicants for settled status are being granted pre-settled status. And that comes with substantially fewer rights. It's a temporary form of leave lasting up to 5 years. It is not indefinite leave to remain. So in addition, well, I'm going to ask the Minister in a moment to come back at me on points, and he might want to respond to that. So in addition to the cliff edge at the end of 2020, when anyone's not applied to the settlement scheme will force possible, in 2021, when anyone's not applied to the settlement scheme face possible deportation, pre-settled status creates hundreds of thousands of individual cliff edges when people come to the point of confirming their individual position, because it doesn't provide. And I see my friend and former committee member looking puzzled about that. But if pre-settled status doesn't provide permanent right to remain, that's only granted at the point at which that gains settled status. We are creating hundreds of thousands of individual cliff edges. Now, the campaign group, the 3 million, have shared with me one case which I think illustrates many of the problems with settled status. It's an older Dutch woman who's been living in the UK for decades. Despite living at the same address for over 30 years, paying council tax, paying income tax, paying national insurance. The online system couldn't find a trace of her. So she was forced to trawl through paperwork to evidence 7 years of residency. For some of those years, she'd saved council tax bills. For others, she had to find at least 6 bank statements for each year. She then faced huge difficulties scanning and uploading the documents. After she'd eventually sent them off, she waited several weeks for a response, only to be told that the Home Office required more evidence. After another difficult process of finding and submitting documents, she was finally granted settled status. But this woman has said herself that she couldn't have done it without help, and her journey shows that although the Act may be simple for the most straightforward of cases, as soon as somebody faces difficulties, it can be immensely difficult to resolve them and secure the right status. And that's also why it's important to have the right to challenge individual decisions. Indeed, under the withdrawal agreement, the government agreed to ensure that EU citizens have a right of appeal against any decision to refuse settled status. Clause 11 of the agreement specifically confers powers for ministers to make regulations providing for appeal rights, but this bill doesn't confirm the provision of appeal rights for all applicants. To that end, Amendment 2 seeks to clarify that EU citizens have the right to appeal a decision on settled or pre-settled status. Now, clearly the government aren't intending to accept any amendments, so therefore I'd welcome the Minister coming back on me and intervening to confirm today on the record that the right of appeal will be created using powers under the withdrawal agreement, and that it will cover all those in the UK, and in particular those who came under the Sambrano and Surinder Singh routes, if he'd like to intervene. He indicates it will come back at a later stage, and I'll be grateful for that. We know that there are particular groups who are at higher risk of not registering. For example, older people, children in care, those with lower language skills, or non-EEA citizens who are dependent on an EU family member. The scheme makes it more difficult for women and disabled people to secure their correct status, and it's therefore likely to be causing discrimination. However, the government's not put in place the tools to effectively monitor the scheme. They're not collecting equalities data, and despite my requesting it on several times over a lengthy period, they've still not published their equalities impact assessment. Now, it's also clearly essential that the EU settlement scheme is properly monitored, and the withdrawal agreement sets up the independent monitoring authority for that purpose, charged with overseeing the government's implementation of the citizens' rights section of the agreement. As set up in Schedule 2 of the bill, the IMA will be neither independent of the government nor empowered to hold them to account, and the government has used this bill to further weaken the authority by permitting its functions to be delegated by secondary legislation. Our Amendment 37 ensures that if the government intends to modify or abolish the IMA, that can only be done through primary legislation. And we'd ask the government to look seriously at that proposal, as well as the other amendments tabled by other opposition parties on the Independent Monitoring Authority. I am coming to a conclusion, so if the Minister wanted to intervene on the point that I made to him. Okay, it's going to come back later in the debate, that's fine. My concluding point then is simply that we need to be carefully minded within the House that there are 5 million citizens whose rights and positions at risk over Brexit, those in this country and those British in Europe. It's essential we get this process right. Our proposals would ensure that every eligible EU citizen and family member automatically has the right to stay here, which the government isn't providing for within this bill. They put their right to appeal in, that we put the right to appeal in law, and that we ensure that the Independent Monitoring Authority can properly hold the government to account. We hope that the House will support us on New Clause 5, and we would ask the government to look seriously at the other issues we've raised.
Hear, hear.
Suella Braverman.
Thank you, Mr. Chairman. I'm pleased to speak in support of Part 3 and Clause 7, and I support all of the comments made by the Minister. When I served as a minister in DEXU, I was responsible for drafting much of this bill, and I'm very glad that a lot of it has survived my absence from government. And I pay tribute to the front bench team, Parliamentary Council and officials for the drafting of what is a complex and critical piece of legislation. In preparation of the bill, we conducted considerable engagement with the charitable sector, representatives of EU citizens and the legal sector to identify their concerns so that we would be designing a new framework that would command their confidence, but above all, that would work. And I should say, generally at the outset, that with Brexit, obviously, free movement will come to an end. That's one of the reasons that many people voted to leave the European Union, myself included. I'm the child of immigrants, and yet I don't have a problem with saying that it's right that our democratic institutions, that our UK government, that the British people have control over migration, not Brussels, not the EU Commission, not the EU Parliament. And I think that's a fundamental aspect of the EU Brexit project that we should all welcome in this House if we are truly to reflect the desires and the needs of those who send us here. But with the ending of free movement of people, when it comes to the 3 million or so EU citizens who are already living and working here, I don't think we can be in any doubt about this government's commitment to safeguarding their position and protecting their rights. We want them to stay, as has been said so many times. We value their immense contribution, and we want to make Brexit as easy as possible for them. And I think that, just generally at the outset, I'm very glad with the proposals contained in this bill. This bill provides for the legal rights for EU citizens. This bill provides for their access to healthcare, social security, recognition of their professional qualifications, and their employment and equalities rights. It's this bill that enables them to continue living their lives as they do now. And it's this bill that provides for the groundbreaking Independent Monitoring Authority, which is a hugely important proposal, which will reflect our watertight commitment to EU citizens. So, firstly, I want to say that this scheme is working, and the Minister himself has overseen the rollout of the settlement status scheme over years now. We've seen, as of October 2019, over 1 million people be granted settled or pre-settled status under the EU settlement scheme. And that milestone came 4 months after the scheme fully launched in March of last year. That's an excellent start, and I pay tribute to the Home Office and all those involved in this immense administrative task. Secondly, the scheme is working because it is practical and user-friendly. The EU settlement scheme is designed to make it straightforward for EU citizens and their families to stay in the UK after Brexit. They only need to complete 3 key steps: prove their identity, show that they live in the UK, and declare any criminal convictions. There's a wide range of support available for EU citizens and their families, including a dedicated settlement resolution centre, 300 assisted digital locations supporting those who have limited access to IT, and a plethora of organisations which are all funded by the Home Office to help those citizens who are more vulnerable, the homeless, the disabled, the elderly, to help them navigate the system. And thirdly,
Very grateful to the Honourable Member for giving way. I wonder if she'd be able to do something that the Minister couldn't. During her time in government, did she see an estimate of the number of EU citizens who would accidentally, or because they didn't fully understand their own immigration situation, how many are going to fail to apply for this scheme by the deadline? Was I right in suggesting it would be hundreds of thousands, and what should happen to them?
I'll come back to that point, but of course any system will have the challenge of reaching everybody who's affected by it. And that's why this government has not held back at all in coming forward with outreach, with engagement, with the publicity and advertising campaign, with the resources made available to the millions of EU citizens who are affected. And we only need to look at the numbers. The uptake rate is very encouraging so far. So I think we should judge it on the evidence, not fear speculative possibilities in the future. Yeah, go.
I'm very grateful for giving me again, and I mean I accept all that, and the opposition spokesperson accepted all that in general it is going well, but the difference between us is the consequences of not applying. Under our system they will still be able to apply for years to come. Under the government's proposed system they will not be. There will be tens, probably hundreds of thousands of people overnight without status. How many does government expect to be in that situation, and what should happen to them?
It's important for any system to have robust deadlines and to have consequences if deadlines are not met. But importantly, there is a grace period in this legislation, which I think allows considerably for that aspect of people being late or delayed in making their application. And I think that strikes the right balance in ensuring robustness, but also making allowances for those who might not get there in time. Thirdly, Mr. Chairman, we know that this system is working because EU citizens and those who work for them have told us so. Charities like the East European Resource Centre or the Refugee and Migrant Centre, which receives Home Office funding and has helped thousands of EU citizens and their families, have both welcomed the operation of the scheme so far. And lastly, Mr. Chairman, the Independent Monitoring Authority cannot be diminished in its significance. It represents not just the legal protections that are offered and provided for in this bill, but a cultural change at the Home Office and in government towards migrants. It's a culture of protection, a culture of safeguarding, and one of enabling people to know their rights and exercise them. Now, much has been said about avoiding the mistakes of Windrush, Mr. Chairman, and I can see exactly why people fear history repeating itself. My parents emigrated to this country from Commonwealth countries at the same time as the Windrush generation and could have easily been caught up in the mistakes and the consequent problems. And when I was a barrister, I did a lot of work in immigration law, representing the government in the High Court and in the immigration tribunals. Of course, any large administrative exercise of this scale can be vulnerable to mistakes. It's an area which is heavily legislated and therefore very complex. Mistakes are made. But there is also abuse of the rules too. And any system must be light touch enough and pragmatic enough to minimise the burdens on those who are directly affected and those who have to go through the system, but at the same time robust enough and sound enough to prevent such abuse. And it's okay to live in an ideal world and assume there's no abuse of immigration rules, but unfortunately the reality is, and I know the Honourable Member will know from his experience in the sector as well, that abuse, unsubstantiated claims, unjustified appeals, thousands of pounds of taxpayers' money being used to perpetuate pointless and vexatious claims through the immigration and the High Court system is something that we have faced in recent times when it comes to immigration law. Now, this government is highly cognizant of its obligations, therefore, to EU citizens. And it has to be said that even without the IMA, there would be many avenues of legal redress for EU citizens. There are appeal rights and judicial review enshrined not only on the face of this bill, but also in the common law. But this government has gone further. It's committing to setting up an independent watchdog, specifically, exclusively, for EU citizens, to monitor the application of the rules, to carry out inquiries, to take up judicial review, to carry out, to represent EU citizens, to be their collective voice and to ensure that mistakes are remedied swiftly. It will be thanks to this IMA that a Windrush-type scandal will be avoided. It will be thanks to this IMA that EU citizens will have a voice. It will be thanks to this IMA that the system will improve and serve people. Mr. Chairman, this is a step change. It's a sign of the political will to get it right and drive forward change. Leaving the European Union presents us with myriad opportunities to take back democratic control of our migration policy. That is something we should be welcoming and should be seeing as an opportunity for our country. And I commend this bill to the House and this section on EU citizens.
Christine Jardine.
Thank you very much. I stand this evening to support Labour's new clause 5 and to put to the vote my own party's new clause 34, which would create a right of appeal when settled status is refused. And I do that partly because shortly before the general election, I visited a school in my constituency where, during the usual chat with students about what they would do after their exams, what careers they would pursue if they'd go to university, one girl told me she was worried about her future. She wanted to go to university, but she was afraid she wouldn't be able to because she'd lived in Edinburgh most of her life, but she and her parents were from a different part of the European Union, and they did not feel secure about what was going to happen to them if Brexit went ahead. This is the only country she really knows, and her parents didn't know where they stand because of the uncertainty and the difficulties they saw with the settled status proposals. And she's not the only one. Like so many in this place, I have colleagues, friends, many constituents who have made their lives here. And these are not the people who, as this government shamelessly claimed during the election campaign, cost us billions and put pressure on public services, strain on school, I will in a moment, thank you, strain on school places and lead to more crime, despite the evidence from their own migration advisory service which showed the opposite. These are people who came to this country to work, to pay taxes, many of them as part of a hugely valuable workforce in our NHS, our university sector, our major private companies. They deserve to have this country recognise that and respect their rights. And this government should do that by standing by the promise that was made to them by the present Prime Minister when he entered Downing Street. And that is why I and the Liberal Democrats tonight will be supporting the Labour Party amendment, as I said, new clause 5, to give automatic rights to EU citizens rather than them having to apply for settled status with the potential of facing deportation if they do not. That is no way for this or any other government or any other country to treat people. I'll give way.
The Honourable Lady for giving way. It's incredibly important that we take every opportunity to reassure EU nationals who, as she rightly says, are so valued in our country. So in those circumstances, did she take the opportunity to give that reassurance to her constituents and say if they simply applied for settled status, there would be vanishingly likely any difficulty with them staying in the UK?
I thank the honourable member for his point, but I'd like to point out to him that what I did was I promised them that I would fight for their rights in this country. I would fight for them to have the automatic... No, I was not scaremongering. I promised them that I would do what I am doing tonight, that I would stand in this House and call for them to have the automatic right to stay in this country where they have lived, where their parents have contributed and paid taxes, without having to apply and face the fear of deportation if they fail. That is what I promised. Our economy, our demographic demands that we encourage people to come here and contribute, bolster our workforce, fill the skills gap we see in the NHS. And that is why I will, as I promised that teenager and the many constituents who've come to me, that I will fight to safeguard their rights, the rights of all EU citizens in the United Kingdom and those UK citizens who have made their lives across the EU by asking for reciprocity. And that is why we have tabled new clause 34 to create a right of appeal if an application for settled status is refused. These people, as I say, deserve so much better than they are being offered by this government. On December the 13th, following the general election, I thought about how that teenager and so many other people who've come to this country must have felt What does the future now hold for them, for her and for her siblings and so many others in my constituency and across the country? People who, through no fault of their own, have had the security of which the honourable member for Cumbernauld, Cassaith and Kirkintilloch East spoke, ripped from them. Many of those people will vote with their feet, and we will lose people in an exodus which shames us. We will lose people who make a valuable contribution to our education and our health service, something which shames this country. People leaving their lives and their livelihoods because they do not feel welcome. The rhetoric of the party opposite, the honourable member accused me of scaremongering. The rhetoric of the party opposite during the election, demonising people and driving us towards a scandal that will dwarf Windrush, was far from acceptable. It's not good enough. The Minister talked tonight about safeguarding rights. But if he really wants to do that, if he really wants to respect the people who have come here and contributed to us being the 5th largest economy in the world, then make their right to stay here automatic and do it now.
Stephen Doughty.
Thank you, Sir George, and thank the many members who made contributions today. I think there have been really important points made and in all the amendments that have been laid down on this crucial subject. And this is, Sir George, an issue which many of us who served on the Home Affairs Committee in the last Parliament examined in great detail, as I've said. And I would urge the Minister, he gave a very rosy depiction of how the scheme was working and how everything was going to work. And of course, we would all like to see people register for the scheme. We'd all like to see people get the right information. We'd all like to see more digital systems that work for everybody. But the reality is that in terms of those of us who have regular daily experience with the immigration system on behalf of our constituents and indeed many of the specific pieces of evidence that we took on the Home Affairs Committee, recognise that the reality is somewhat different. And therefore the amendments that are laid, including those by my own front bench, which I support, are there to improve this system, to ensure that it actually delivers the rights that were promised to EU citizens and EEA citizens who have been resident in this country for many, many years and who have, as many have spoken in this debate, made clear, have made huge contributions to our communities and our country as a whole. Certainly in my own constituency, the contribution of EU citizens is immense over many, many decades. And I've had many constituents coming to me with concerns over the past few years about this scheme and raising the very concerns which are reflected in the amendments which many of us are supporting this evening. And it's not scaremongering, Sir George, when we look at the record of the Home Office and the continued failures on a series of issues, because we only have to look back to 2017 when the Home Office sent letters to 100 EU citizens telling them that they had to leave the UK immediately, an episode which the then Prime Minister, the member for Maidenhead, had to apologise for. In 2018, members of Parliament were sent letters about the importance of applying for the EU settlement scheme, even though they were not EU nationals, an extraordinary situation which the then Home Secretary had to explain. And of course, one only has to look, Sir George, at the regular monthly statistics from the Home Office to look at the number of cases of wrongful deportations, wrongful detentions as a result of the hostile environment policies, as a result of mistakes and problems, absolutely why those appeal rights are so crucial. And look at the compensation payouts that are made. This is costing government money when the Home Office is making mistakes. And with all of those examples, Sir George, and indeed, of course, the example of the Windrush scandal, which was so shocking and so shaming to our country, to have treated so many people who contributed to our country in over so many years in such incredible ways, ringing in our ears, we should be taking these issues incredibly seriously. And therefore I'd urge the Minister, I'd urge the Government, and particularly urge those in the other place when they're examining these parts of the bill, to look seriously at ways in which this part of the legislation can be improved so we can deliver on those commitments. Because I don't doubt the Minister's intent. I'm sure he's sincere in wanting to provide EU citizens with the rights that they deserve. But the practical reality is often different. And I wanted to raise with the Minister the specific point about the physical documentation. Of course, we all want to see digitisation. We all want to see more efficient systems. We all want to see a system where we can quickly get information, whether that's employers or housing providers or other providers of services, to ensure that people receive the things that they're entitled to under the law. But the reality is that we all know these systems break down, there are mistakes in them, names are entered incorrectly. What is the backup? What will happen when somebody's trying to apply for a house or trying to access medical services or trying to apply for a job or trying to apply for education, which they are entitled to in this country, and yet the system breaks down, the computer says no, the blue screen death comes up on the computer, whatever it is. We all know these things fail, and when we're talking about such a fundamental thing as the right to live and work and exercise rights in this country, which many EU citizens, of course, should have and deserve under this legislation, then we have to ensure that there is backup. We have our birth certificates, we have our passports, we have a physical document for the most crucial aspects of our rights and citizenship rights in this country. And I just caution the Minister that when those mistakes happen, when there is the inevitable breakdown, when there's a cyber attack on the system, when it's unavailable, what is going to happen to the people who get caught up in that? All of that will generate not only huge cost for government in terms of rectifying those mistakes in due course, but also great harm and great concern to the individuals caught up in them. And anyone who deals with the immigration system, as I said, Sir George, on a weekly basis, as many of us do, can point to myriad examples. There's also the crucial issue, and my honourable friend who served with me on the committee raised this, about the numbers here. No exercise on this scale has been attempted before, the registration of millions of individuals in this system, and inevitably problems are going to occur, not least when the government themselves cannot tell us exactly how many EU citizens and EEA citizens there are lawfully resident here in the UK, but also they cannot tell us, as has been asked on a number of occasions, how many people they estimate will have not applied by this deadline which is now being put into place. And I find that deeply worrying that a policy is being suggested here and being proposed to be implemented without even knowing the number of people that it is going to affect. And of course we do not want to see unlawful detentions, unlawful deportations of individuals, which we have seen sadly in the past, and the harm that those cause to individuals whose rights are then affected. But fundamentally, Sir George, this gets back to some fundamental promises that were made not only by the current Prime Minister, but by the previous Prime Minister, and of course indeed by those who advocated leaving in the first place. And the 3 Million campaign, who have done so much good to highlight the concerns of those affected by these changes, rightly pointed out that in the referendum in 2016 it was made clear that there should be no change for EU citizens already lawfully resident in the UK. EU citizens will be automatically granted indefinite leave to remain and will not be treated any less favourably than they are at present. That was a clear promise, that was a solemn undertaking. It's an undertaking that's been repeated by the Prime Minister, by ministers since. I have no doubt that the Minister intends it in good faith, but the reality here is that when the reality of accessing this scheme, demonstrating those rights, being able to prove that those rights are being lawfully exercised, I think it will be very different, and I think we will be picking up the pieces of this, Sir George, in years to come, and so I would urge the Minister to look again very carefully at these amendments.
I'm going to call Sir Desmond Swain, who is known for many things in this House, not least of which is his brevity. Desmond Swain.
Thank you, Sir George. I am persuaded that the amendments are unnecessary and I support the provisions of the bill. But just one word of caution. I have received a number of inquiries from constituents, European citizens, who clearly haven't been reached at all by any of the outreach. Such are the basic questions that they ask. Indeed, I received one today. Now, on that score, when I think about it, I don't know if I've been living in a bubble, but actually I haven't seen any of that outreach at all myself. Admittedly, I've not been looking for it, but nevertheless, I just ask ministers to re-examine the outreach that there has been and reassure their level of confidence that it's adequate.
Bambos Charalambos.
Thank you, Sir George. I'll be speaking in support of New Clause 5 and New Clause 18. In my constituency of Enfield Southgate, constituents have contacted me to raise serious concerns about the rights of their family and friends who are EU citizens but aren't eligible for settled status. But who may not be able to, who are eligible for the settled status, but may not be able to complete their application in time, or may be unaware of the deadline. And this is a particular issue among the elderly EU citizens, some of whom may have serious medical conditions that may impair their ability to complete forms. One constituent told me about her mother, who was in her 90s, and who came to the UK as a refugee from Poland just after the Second World War, but has never needed to apply for citizenship. She now has Alzheimer's, and had it not been for the help of her daughter, she would be losing her right. She would be at risk of losing her right for not being able to apply for settled status. There is no doubt other people like her. As the Minister stated, we want to avoid another Windrush situation. And as has been mentioned, the IMA is no substitute for a safety net to protect people's rights that they're at risk of losing. Now, it's been suggested that legal redress can be achieved outside a tribunal system. But if it is available, what would be the cost of that? There are huge fees that are incurred in people trying to get redress for their legal rights, and these fees are astronomical. On the issue of fees, one of my constituents, Martin Janu, has a wife who's Spanish, and she's fearful of potential erosion of her rights under settled status. So she's applied for citizenship, but that's at the cost of £1,400. Having such high fees for applications for citizenship and also for visitors' visas is nothing more than a racket by the government ripping off these applicants. In short, EU citizens who have been here lawfully and do qualify for settled status should not have their rights limited. I'll give way.
I thank my honourable friend for giving way, and the case point he's making, I had a call literally 3 days ago from a constituent who rang me, who said his wife, who's French national, they've been married for well over 40 years, she has worked as a teacher in our school, is on a pension now, and he was worried about what would happen, she's worried about what's going to happen to them. And we actually I actually went onto the Home Office website, and I was trying to guide them through as to what they need to do. But they're worried about what's happening to them, and of course the cost of all these processes. So it's very important that we have safeguards in place.
My honourable friend makes an excellent point. We do need to have these safety nets in place, and these clauses actually provide the safety nets that we need to ensure that people's rights, no matter how few those people might be, are protected. In short, EU citizens who have been here lawfully and do qualify for settled status should not have their rights limited by any barriers such as time limitation or fees. If the government do not listen to these warnings, then there's a very real risk of another Windrush. The government will then have been found to be asleep at the wheel as another scandal is avoidable. This is unacceptable, totally avoidable and easily remedied. I therefore invite the Minister to accept new Clause 5, new Clause 18 and new Clause 34. Thanks.
Minister.
Thank you, Sir George, and I will be brief. I just wanted to respond to a couple of points raised. The Honourable Member for Sheffield Central gave a quote from me in an interview with a German journalist, if I recall correctly, some time ago. Sadly, he didn't give the whole quote, which means that colleagues probably aren't quite aware of the point that was being made, which is that actually the whole point of the structure of how the EU settled status scheme works is to ensure that nobody is left behind and that all rights are properly protected. That's why not only are we running this scheme until the end of July 2021, but we have also said, and I said at the dispatch box today, that anybody after that stage who comes forward who hasn't acquired settled status and hasn't applied for it for a good reasonable reason, we will be looking to grant them status as well. This scheme is based on a very different principle, taking a comment from the member for Cardiff South and Penarth earlier on, no, I won't give way at the moment, made in his speech, and I just said, no, I won't be giving way at the moment, was that actually the whole process of this system is different to previous systems. We are looking to grant status, and I want to give great credit to a superb team, Home Office civil servants working particularly in Liverpool, who have delivered this scheme, a scheme that, as he said, is unprecedented in terms of now having taken over 2.8 million applications, already processing some almost 2.5 million of them. And just again to be clear with colleagues, in that almost 2.5 million that have been processed, I can confirm only 5 have been refused, all on grounds of serious criminality. And I think it is right that we do those checks and we make sure that there is proper evidence. And I would just go a bit further to the Honourable Member for Sheffield Central's comments around the difference between pre-settled status and settled status. And what he said at this dispatch box, I think, is part of the risk we have of some people creating this scaremongering regime that they have been portraying in a couple of the speeches this evening. Pre-settled status is a pathway to settled status to ensure that people, once they've lived in this country for 5 years or more, have those rights fully secured. And there is no issue about a cliff edge. When somebody has lived in this country for 5 years or more, having got pre-settled status, they can move straight to full settled status. Their rights are the same and they are protected from the moment they have got pre-settled status. And the evidence, I think, is an important part of that. He asked a very specific question about appeal rights, and yes, appeal rights apply to all cases under the EU settlement scheme, which also comes to the point raised by the Honourable Member for Edinburgh West. The Honourable friend, the Member for Fareham, is absolutely right. We are determined to make sure we are we are delivering on the rights of EU citizens, and that we in this country play our part in delivering on the promises we made. I'll give way briefly to the Honourable.
I thank the Minister for giving way. When he says all citizens, does he include those who came under the Zambrano and Surinder Singh routes?
Yes. Absolutely. And I would just say to my honourable friend, the member for New Forest West, we are always reviewing the outreach work. Myself and the Home Secretary are particularly focused on this work to make sure that it's not just giving good value for money for the taxpayer, but it is also reaching those hardest to reach places and communities in the country. We are working with some 57, I think it is, voluntary organisations around the country, and with commercial organisations who employ large numbers, and public sector organisations who employ a large number of EU citizens. And we will be looking to continue to do that work and drive it further and further. It is important that we encourage people to apply for that settled status. It is simple, it is quick, it is easy, it delivers on people's rights, it delivers on our promises, and that is why we will not be accepting any amendments or new clauses this evening.
For the benefit of new members in particular, although the Minister has responded to the debate, I'm now going to call the mover of the lead amendment to conclude and respond to the debate. Stuart C. MacDonald.
Thank you again, Sir George, and to thank all honourable members for their contributions to what I think has been a robust and very helpful debate. I think every single speaker spoke of the contribution that EU nationals make to this country and the importance of protecting their rights. So far, so good. But beyond that, there are fundamental differences about how best we do that. On this side of the House, we say automatically protect their rights in law. That means that nobody will lose their rights overnight. On the government side of the House, they say apply to stay, and the government has not challenged at all the assertion that we've made that that almost certainly means that tens, probably hundreds of thousands will overnight potentially lose their rights. Now, the Minister, just summing up there, said, well, there will be a period where anyone with a good reasonable reason for missing the deadline will be able to get that all fixed. We are talking about possibly a six-figure number here. And what is a good reasonable reason? During my original speech, I gave two hypothetical examples. One of a French lady who's been here since the 1970s. She's retired. She had permanent residence under the old EU scheme. She doesn't think she needs to apply. There are lots of folk in that boat. Well, is that a good reasonable reason? She didn't think she had to apply. What about the Polish guy that I cited in my speech as well? He was born in the United Kingdom. He therefore thought that he was British because his father was British. But in actual fact, because of his parents' marital status at the time of his birth, he is not British. He fails to apply. Is that a good reasonable reason? He thought he was British, but he was wrong about nationality law. There will be tens of thousands of cases just like that, and the government has done absolutely nothing to reassure us about the cliff edge that awaits us. Amendment 5 goes some way to solving that by putting in place a declaratory system. The opposition new clause 5 is more comprehensive, so in the meantime, Sir George, I beg your leave to withdraw Amendment 5 so that we can support new clause 5 instead.
Thank you. So, on the basis of what the honourable members just said, is it the pleasure of the House, the committee, that the amendment be withdrawn? And many of that opinion say aye. Amendment by leave withdrawn. The question is that clause 7 stand part of the bill. As many of that opinion say aye, with some enthusiasm perhaps. Many of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now, with the leave of the House, I will now put together a single question on all clauses and schedules to be agreed at this time, before calling on certain members to move new clauses formally. The question is that clause 8 to 14 stand part of the bill, that question 1 be the first schedule to the bill, that Clause 15 stand part of the bill, that Clause 2B, the second schedule, that Schedule 2 be the second schedule to the bill, and that Clauses 16 and 17 stand part of the bill. As many of that opinion say aye? Aye. Of the contrary, no. I think the ayes have it, the ayes have it. Before I call on a member to move the first new clause selected for separate decision, I should inform members that the split of letters at the desks in the division lobbies has changed slightly. There's a treat. Members whose surname begins with G will now need to go to the middle desk instead of the left-hand desk. There have been no other changes. The distribution of the names is different in the new Parliament, and the revised lettering should mean that the queues at the desks are more even. We now come to Clause 5. I call on Paul Blomfield to move new Clause 5 formally. The question is that new Clause 5 be read for a second time. As many of that opinion say aye? Aye. Of the contrary, no? No! Division, clear the lobby.
So to put the question again.
The question is that as many...
That new clause 5 be read a second time.
Sorry, the question is that new clause 5 stand...
Be read a second time.
Sorry, we don't come... The question is that new clause 5 be read a second time. The tellers for the noes are Tom Pursglove and Nigel Huddleston, and the ayes, Jeff Smith and Colleen Fletcher.
Lock the doors. Order! Order!
The ayes to the right, 252. The noes to the left, 342.
Thank you. The ayes to the right, 252. The noes to the left, 342. So the noes have it. The noes have it. Unlock. We now come to new clause 18. Stuart MacDonald to move new clause 18 formally.
Move formally.
Thank you. The question is that new clause 18 be read a second time. As many of that opinion say aye. Aye. Of the country, no. No. Division. Clear the lobbies. The question is that new clause 18 be read a second time. Is that opinion say aye? Country, no. Tell us for the ayes, Marion Fellows and Owen Thompson. Tell us for the noes, Tom Purscliffe and Nigel Huddleston. Lock the doors. Order! Order! Colleagues, please take their seats. Thank you.
The ayes to the right, 255. The noes to the left, 341.
Thank you. The ayes to the right, 255. The noes to the left, 341. So the noes have it. The noes have it. Unlock. Thank you. We now come to new clause 34. Christine Jarling to move new clause 34 formally.
Moved.
Thank you. Questions that new clause 34 be read a second time. Let's make that opinion say aye. Aye. Contrary no. No. Division. Clear the lobby. Question is that new clause 34 be read a second time. Let's make that opinion say aye. Aye. Contrary no. No. Tellers for the ayes, Christine Jardine and Alistair Carmichael. Tellers for the no, Tom Persglove and Nigel Huddleston. Lock the doors. Order! Order!
The ayes to the right, 251. The noes to the left, 343.
The ayes to the right, 251. The noes to the left, 343. So the noes have it. The noes have it. Unlock. Order. Order.
I beg leave to report that the committee has made progress and ask leave to sit again.
Committee to sit again what day?
Tomorrow.
Tomorrow.
Chairman. I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Stuart Malcolm MacDonald.
Thank you very much, Mr. Deputy Speaker. I shall perhaps, given we have extended time...
Members leave quietly, please. We're still engaged in a debate. Mr. MacDonald.
Thank you, Mr. Deputy Speaker. Given there is extended time, I'll perhaps let members rush out as quickly as possible, because the affairs, as I'm sure the government front bench understands, are hugely important and deserve proper attention and scrutiny of the House. Mr. Deputy Speaker, I should say at the outset that there is absolutely no joy in bringing this debate to the House this evening, but it is indeed an important debate. It follows, as the Minister knows, the joint Sunday Times and Panorama investigation on the role of special forces and UK personnel in Iraq and Afghanistan that contains some of the most serious allegations, including allegations of war crimes that have been committed and subsequently covered up by members of the armed forces and perhaps even ministers themselves. Mr. Deputy Speaker, I should lay out at the very beginning the high regard that I and these benches hold members of the armed forces in. I can see two defence ministers on the front bench who I know this already. But the high regard we hold them in is matched only by the high standards that is placed on them by the government on behalf of the British public, and rightly so. Indeed, the Minister responding this evening knows this better than most. I certainly will.
When sought his permission beforehand to do so, does the honourable member agree with me and recognise that our British Army have served in the most difficult wars and conflicts, and that their courage and bravery is never in doubt, and that every soldier has been subject to traumatic and stressful circumstances, and that the MOD must ensure that every soldier receives the legal advice and the help that they need?
He's entirely correct to make that point, and I thank him for making it early, Mr. Deputy Speaker. The two theatres of conflict that are in the title of this debate this evening, Iraq and Afghanistan, are two of the toughest, and indeed he's right to mention that members of the armed forces perform their duties in some of the most extraordinarily difficult circumstances. But it's entirely right, as he and I discussed before this debate, that standards are upheld, and I know that the government front bench agrees on that. It's entirely right that this House expects the government to live up to what the Geneva Conventions require. As I said to the Secretary of State earlier in a different but not entirely unrelated statement, there should be an unforgiving quest for truth and to uphold rules and laws. But I'll return to that later. And in truth, these affairs can get uncomfortable for officials, for ministers, and for serving personnel. But it's entirely right, entirely appropriate, Mr. Deputy Speaker, that we grapple with them in the most forensic fashion not least because of the government's announcement in the Queen's speech and long-held plans for which the Minister responding has been a champion of, to perhaps change the rules around what can be investigated for members who have served in Northern Ireland. Mr Deputy Speaker, I want to say at the outset, in terms of the joint investigation by the Sunday Times and Panorama, that that was an extraordinarily important piece of investigative journalism. I am quite sure that all the ministers in the front bench have furnished themselves with the details of it from top to bottom. And I want to thank those journalists and investigators who have taken the time to take part in that. Investigative journalism is important, especially on these affairs, as a mechanism in a democratic society to arrest any temptation to sweep over these matters or any temptation of a corrupting view to set in. And the important thing about the allegations that have been uncovered, hundreds of documents and statements, is that they aren't made by what the former Prime Minister called ambulance-chasing activist lawyers. Nobody wants to see vexatious claims being made. But these allegations were made by serving members of the armed forces. They were made by military intelligence officers and government-appointed detectives. Mr Deputy Speaker, even with the extended time we have this evening, it wouldn't be possible to get into the detail of every case that was uncovered in that piece of journalism. But I do want to adumbrate some of the things that it brought to our attention. Degrading and inhumane treatment, the unlawful killing of civilians, faulty intelligence, doctored and amended statements when affairs have been investigated, including by the Royal Military Police, evidence of torture at Camp Stephen in Basra. And anyone who has read that journalism or watched the Panorama programme cannot fail to have been shocked by what appears to be a ruthless and coordinated effort to close down these investigations. As I mentioned, Mr Deputy Speaker, it won't be possible to go into all the details of them this evening, but I'm sure the Minister will understand that I may wish to follow up on some of the specifics with them in writing afterwards. But I plead with the Government in its entirety, not least the Minister who responds this evening, to be judicious in their response and in their handling of these affairs and approach them with the seriousness that they deserve. Because there is also the case, Mr Deputy Speaker, of the shooting of 3 boys and 1 young man in Afghanistan, shot in the head. The premise being that they were Taliban insurgents, but the joint investigation has told us that no such evidence was ever produced. That was passed to the Service Prosecuting Authority, and a recommendation of war crimes charges came forward, and a cover-up then ensued by military officials. Serious questions about why these allegations appear to have been whitewashed in the way that they have been need to be addressed. Mr Deputy Speaker, it is also the case that both in Iraq and in Afghanistan, false information was knowingly given to the victims' families, whereby in Iraq in particular, 2 civilians who had died in the care of the Black Watch, their families had been told that it was days after they were arrested that they died, that they were in hospital, and that was never the case. And that happened with less than a week between those 2 cases. What looks like a coordinated effort to evade justice simply will not hold. Indeed, I was talking to some members of the government benches earlier and was reminded that this stuff has a habit of coming back to bite if it's not dealt with properly. And it may be that it comes back in the most serious fashion imaginable. I support Lord Ken MacDonald's calls for these affairs to be reopened and investigated properly via a public inquiry led by a judge. But it could be, Mr Deputy Speaker, in one moment, it could be the case that this ends up with the International Criminal Court. It's hard to think of a more seriously grave situation that the government could find itself in. And I give way to the honourable member.
He's making a very powerful statement, and I'm sure that all members of the House will be taking note of what he's saying. But would he agree with me that this serves to highlight the fact that we really need some kind of parliamentary mechanism to delve into and investigate these accusations and claims which are being made?
It's almost as if you could see the notes in front of me, because I'm coming to this exact point, Mr Deputy Speaker. In terms of the allegations uncovered in the joint BBC Sunday Times investigation, I think that has to be taken out of the hands of the government and given to an independent inquiry led by a judge. I don't think any honest person could disagree with that. However, he touches on a wider and important point, which is the broader ability of this Parliament to hold to account Special Forces operations, woefully lacking in this country. We are being outdone by the United States, in terms of the oversight that it has of Special Forces. In the modern age that the public expects there to be proper parliamentary scrutiny and parliamentary oversight, this system needs updating. Now, clearly that can't be a free-for-all where every single member of the House can access information on live Special Forces operations. Only a fool would suggest such a thing. But it cannot be beyond the collective imagination of the House. Indeed, it can't be beyond the collective imagination of the small group of members, some of whom unfortunately are no longer with us, who regularly attend the debates on defence, to compose a mechanism by which we can catch up with the United States, whose system is not perfect, but it's something, catch up with Denmark, catch up with Norway, and have proper oversight of Special Forces operations. Indeed, it has been mentioned before in the House, to great resistance by the Conservative benches, but it's been mentioned by both the Labour opposition and the Scottish National Party that the time has come for us to introduce a proper War Powers Act. And I say to the government, it's better to take this stuff on now. It's better to have a serious parliamentary debate about the scrutiny efforts that this Parliament can take forward before this ends up in the International Criminal Court, which nobody wants to see, but it may well be that it's heading there. A failure to deal with this properly, a failure to be judicious and sober in approaching these matters, a failure to ensure that justice is done and the pursuit of the truth is absolutely unforgiving, is nothing short of an assault on our values. It's worth remembering that the International Criminal Court was set up with the United Kingdom's enthusiastic support, and rightly so. As I said earlier, I don't want to see this end up in the International Criminal Court. I'm quite sure the Minister doesn't want to see it end up there, and he has an opportunity, I think, to ensure that it doesn't. But to conclude, Mr Deputy Speaker, against a backdrop of assaults on the international rules-based order that the government tells us day in, day out it wants to defend, it wants to uphold, then surely we must respond to this mind-blowing investigation properly. I detect the former chair of the Defence Select Committee wishes to intervene.
Before the honourable gentleman concludes, could I ask his opinion about whether he feels that a mechanism similar to that of the Intelligence and Security Committee, which conducts investigations into matters relating to the intelligence agencies that cannot be discussed on the floor of the House, might not be a slightly more appropriate response than the much wider aim of a War Powers Act with all that that would entail.
Well, it sounds to me like I have an ally in the former chair of the Defence Select Committee, because I think that part of the remit of the judge-led inquiry that I have advocated on the floor of the House tonight should be to make a recommendation to the House as to what mechanism the House or the government brings to the House so that these operations can be properly scrutinised. I think the ISC would be an obvious outfit for that. I know that other members perhaps would disagree with that point, and I'd be happy to let the right honourable gentleman come in at that point.
Thank the honourable for giving way. I mean, it seems to me that he's making 3 points, and they are separate. One is the question of the War Powers Act. I was a co-signatory with Mr Tony Benn 20 years ago in a call for a War Powers Act. So that's one issue about the role of the House in approving conventional wars over and above Article 5 responses, defensive actions. Secondly, there is the question of oversight of Special Forces operations. I have doubts about that because of the cramping effect on our ability to respond flexibly to really quite serious non-full war operations. The third, it seems to me, is very important to distinguish, and these are the allegations, they are just allegations at the moment, that have been put by the reporters and repeated by him. Though the proper response to those are actually criminal actions. And that needs to be not an inquiry by this House, but proper investigation and proper criminal prosecution by the authorities, independently by the authorities. And I'll say this to him. All the soldiers I know, senior Special Forces soldiers and senior generals and operational officers in the field today, would welcome that, because no soldier wants to be fighting from the low moral ground. Yeah. A British soldier wants to be fighting from the high moral ground, and in that, at least, we are in the same place.
I thank him deeply for that intervention. He is, of course, entirely correct. I would just come to the second point that he picked me up on in terms of the oversight question. Nobody wants to deny flexibility. Clearly, there has to be an ability to respond. I don't think, and we discussed earlier that the US system is not perfect, but I don't think anyone can say that President Trump feels particularly inflexible as a result of the oversight mechanisms that exist on Capitol Hill. I'm not suggesting we mirror those in their entirety, but he's a great authority on these affairs. And I think it's time that, it's only my proposal at this stage, that if we have a judge-led inquiry that does investigate these matters, part of that remit could be to make a recommendation to the government, to the House, as to what the best means of moving forward for proper oversight would be that doesn't compromise flexibility, doesn't compromise security, because nobody would want to see that, certainly.
I'm grateful for my honourable friend for giving way. In relation to the issues of oversight, there's one thing to have oversight if it doesn't change the culture of acceptable behaviour which has brought about this investigation. And one thing this House consistently does is reject the idea, first of all, that members of the armed forces are employees, because that's actually been objected to by members of the government on the front bench, and that for those of us on this side of the House, at least there's an acceptance if we want to change culture, we need to treat members of the armed forces as employees and also give them a trade union.
He tempts me down another path entirely that he knows I agree with him on, but his broader point is entirely spot on, and I know he has spent a lot of time over the past 2.5 years that he's been a member of the Defence Select Committee looking at these matters. So he speaks with some degree of knowledge on them, certainly.
Well, I have sympathy with much of what you're saying, and indeed the former chairman of the Defence Committee. But the point of the right honourable member here, that this could be crippling, I think one needs to balance it quite carefully. I mean, let's not kid ourselves. You know, our top soldiers do not go out wanting to commit war crimes. They go out in very confused, dynamic, frightening situations, operating with imperfect information to take on people who would otherwise hurt our constituents. So I think we need to keep that firmly in mind and not sort of imagine we've got some great problem of, you know, crazy guys with unseasonal suntans running around killing people. That is clearly not the case.
That's an allegation I have not made, Mr. Deputy Speaker, and that's important to remember, because I agree with what he just said. Of course, members of the armed forces don't go out wishing to commit crimes and atrocities. Of course they don't. I don't allege that. And I should just say, in response to what the right honourable gentleman says, the allegations, and they are just allegations, don't come from reporters. They're exposed by reporters. They come from members of the armed forces. And the problem with what has happened, especially in the Afghan case, the shooting of 3 children and 1 young man, where there is video evidence available of what that soldier went into in an extremely tough situation, as he mentions. That video evidence has been concealed from top members of the armed forces, people who are cleared, security clearance exists for. I don't know if he's watched the BBC Panorama, but I highly suggest he does so. It's got about 90 days left on the iPlayer, so there's plenty time to do so. And tonight, clearly we're not going to resolve this tonight and get into all the details tonight, but tonight has to be the start of a proper, judicious and sober parliamentary discussion to ensure that the government front bench acts appropriately. Because as I was saying, Mr. Deputy Speaker, the assaults on the international rules-based system, which can change depending who uses the phrase, are coming at us from all angles. So let us be the ones who say no more. Let the government come forward and do the right thing. Let the government come forward and say this will be uncomfortable, but it's entirely right that we are held to the standards that we're supposed to be held to under international law, that we do have high standards for serving members of the armed forces, and we will not put up with any concerted effort to cover this up. Let us shine a light on this stuff. Where I think there's a problem politically is that there have been vexatious claims made. Clearly there have been. I don't want to see that any more than the Minister wants to see that. In fact, I want to see it dealt with, but I want to see it dealt with properly, and it can't be used as an excuse to shut down any discussion, close off any avenue of investigation into the seriousness, the deep, deep seriousness that has been uncovered by the joint investigation. I will briefly.
Of course, we know that the majority of our armed forces who have served in these theatres have served with integrity and honour at all times, but we do not support them in their integrity and honourable behaviour by failing to investigate these allegations. In fact, we must investigate, and the investigation must also include an investigation of the victims. And until we do that, we don't properly support and we don't properly stand up here in this House and say we can defend the actions completely and utterly of our armed forces unless we properly investigate them.
She's absolutely correct, because ultimately the rules and the laws exist to protect serving personnel, as well as to protect those who are in the theatre of conflict that they are deployed to. The rules and the laws are there to uphold the very honour that we come here and pay tribute to in this Parliament. So let me, if he doesn't mind, I want to finish with this. As I mentioned earlier, the government tells us they always want to uphold the international rules-based system. I suspect we have different views on what that can mean, but this isn't it. This isn't it. So I invite the Minister and I beseech him. Clearly, he can't make any promises to me this evening, but the government must set up an independent inquiry into the allegations that have been made by fellow members of the armed forces. We need to know what took place. We need to know what the Royal Military Police was doing. Why were statements amended? Why were faulty intelligence leads followed? resulting in the deaths of civilians and their families lied to. Their families deserve better. Our armed forces deserve so much better. So whilst there's a broader political debate on oversight, which it sounds like I have some allies across the House in ensuring that is on the agenda, I ask the Minister tonight, especially given the intentions of the Government in relation to Northern Ireland, to approach this appropriately, to come to the dispatch box and make clear that there will be an unforgiving and relentless pursuit of the truth and of justice. And if he does that, I'll back him all the way.
Minister.
Thank you very much, Mr. Deputy Speaker. And can I start by congratulating the honourable member for Glasgow South for securing this debate. He covered a lot of ground. I want to try and stay within the remit of tonight's debate. I think he has some very interesting ideas, and in me he has someone with a very contemporary view of defence. I think we need to modernise some of the things we do, but a lot of that is for another day. What is hugely important is that Parliament and the public should have confidence in both how our armed forces conduct overseas operations and how allegations of criminal behaviour are investigated. This issue is highly topical in the wake of both the recent allegations by the Sunday Times and the BBC mentioned by the honourable member, which I will address in my reply, and as this Prime Minister has asked me to address the long-standing unacceptability of how we deal with historic prosecutions against servicemen and women, often decades after service. But from the outset, I want to be very, very clear with the House and the country. There have been many words written and said about what I have tried to do, both previously from the backbenches and now on behalf of the UK government when it comes to historical allegations against our servicemen and women. These are almost always inaccurate and usually simply seek to answer one side of the debate or satisfy one party in the argument. So let me be absolutely crystal clear. You will not find any individual in this House more committed to prosecuting those who break the law whilst in uniform than me. Many of my cohorts operated in harsh and chaotic circumstances over many years, whilst remaining firmly within the boundaries of the law. Like all of us, I hold no truck whatsoever with those who were or are unable to operate within the constraints placed upon them as a professional member of the UK's armed forces which still today remain the envy of our peers. But I am equally clear that there are few higher sins of government than to expose those who volunteer to serve and ultimately sacrifice on this nation's behalf, to subject them to years and years of interminable court processes, allegations, and deep personal distress simply as a result of serving this nation on operations. Where there is clear evidence of crimes being committed, I and this Prime Minister are unequivocal. Individuals must be held to account for their actions, irrespective of time past. But we will not allow veterans in this country who have committed no crime to be exposed to endless legal processes well outside of the original intended scope of the laws under which they are brought, hounding some of this nation's finest people years after service. Yes, of course.
I hear what the Minister's saying, and I carry a lot of sympathy for it. But if he doesn't deal with this properly and quickly and appropriately, then the problem won't be courts in the United Kingdom. The problem might well be the International Criminal Court.
So with respect to my honourable friend, I have dealt with this for years now, including before I came here, and the last individual who wants to see this country go to the ICC to deal with these allegations is me. But I would reiterate the point raised by my honourable friend, who's not in his position anymore. These are allegations. They are allegations at this stage, and I will come on to that at the moment. So, yeah, I'm just going to make some progress, and then I'll come back to you. A balance has to be struck. A balance has to be struck, and we will seek that in this Parliament. starting with primary legislation, which I will shortly be laying before Parliament. And it is in this very careful space that I would encourage those who are sort of deliberately ill-informed or who simply want to politicise and rewrite history not to enter, and I do not include my honourable friend with that, clearly. I will answer some of the points raised about the conduct of UK armed forces in Iraq and Afghanistan over the last almost 20 years. I just want to expand on that very briefly, given we have a little bit of time. I can't overestimate the pain caused to the families of those who are victims in these situations by ill-informed debates in this space around amnesties and other options that are simply not considered. There can be no time bar on prosecutions, and this government is very, very clear about that. And I would urge everyone who takes part in this debate to do so cognizant of the victims and of people who are being hounded in this process too. So, Mr. Speaker, Mr. Deputy Speaker, you will be aware of the long-standing policy of successive governments not to comment on the activities of our special forces. This neither confirm nor deny policy is an essential element in enabling this strategic asset to operate effectively. I am unable, therefore, to speak in any detail about the vital role that our special forces played in Iraq and Afghanistan, and will have to confine myself to making observations about the allegations more generally. On the basis of 5 specific incidents, 2 from Iraq and 3 from Afghanistan, the Sunday Times and BBC make 4 broad allegations. First, that we operated death squads in Afghanistan. Secondly, that there has been a systematic attempt by the MOD not to investigate allegations. Thirdly, that the MOD has applied pressure to terminate investigations prematurely. Fourthly, that the MOD has sought throughout to ensure that war crimes in Iraq go unpunished. Mr. Speaker, the BBC wrote to the Ministry of Defence prior to broadcast, setting out these and other allegations which were not repeated in its Panorama programme. The MOD promptly forwarded these letters to the Service Police and the Service Prosecuting Authority. The Service Police have reviewed these and the programme and have confirmed that in relation to those 5 incidents, the Sunday Times and the BBC have not produced any new allegations or any new evidence that had not already been considered. I would repeat this now from the dispatch box to the House and beyond. Anyone who has any evidence, and that is the key word, evidence, you have a duty to come forward and let independent police officers examine that evidence. The allegations are deeply disturbing, and as perhaps the most prominent voice on increased legal protections for our armed forces, I wish to satisfy myself personally on them. These investigations are never closed. Any evidence will be looked at in an independent, professional manner to this day. As you would expect, the International Criminal Court is considering the BBC's allegations as part of their preliminary examination into alleged war crimes in Iraq. The government is continuing to cooperate fully with the ICC, and we expect to be able to satisfy them that the Service Police have appropriately investigated all allegations. I was going to give way to my honourable friend.
Thank the Minister for giving way. Of course, we know that the UN has identified cases of 300 civilians who have been unlawfully killed. Now, if there are 300 civilians who have been unlawfully killed, there are people who have done the unlawful killing. So I would like to know what steps are being taken to properly investigate these killings to ensure that we have the answers and there is scrutiny as to the operations of the armed forces.
So I'm about to come on to civilian casualties. And I'll cover that in detail. Every civilian casualty is reported to the military police, and I'll cover that in a moment. Firstly, though, let me deal with the allegation that our armed forces operated so-called death squads in Afghanistan. This is simply not true. Our armed forces did conduct many daring operations to capture Taliban insurgents. However, these are not kill or capture operations. Rather, they were carefully planned capture operations with the object of capturing known Taliban insurgents and their associates. While every effort is taken to minimise the risk to any civilians who are present during such operations, It is simply an unfortunate fact that the risk of civilian casualties in war cannot be eliminated altogether. Irrespective of the unit involved in any operation, civilian deaths were reported to and have been independently investigated by the Royal Military Police. All three of the incidents cited by the Sunday Times and the BBC have been investigated. The RMP referred one case, the shooting of Faisal Mohammed and 3 Afghan miners, to which my honourable friend refers, to the Service Prosecuting Authority, which, having obtained independent legal advice outside of the Ministry of Defence from senior external counsel, decided that the evidence did not establish a realistic prospect of conviction. In the other two cases, the RMP concluded that there was insufficient evidence of wrongdoing and did not refer any soldiers for any offence. Mr. Speaker, it is simply not credible to suggest that, given the scale of the resources expended by the MOD on investigating alleged criminal behaviour in Iraq and Afghanistan, that it demonstrates there could have been a systematic cover-up. Over £40 million has been spent today to this date on the Iraq criminal investigations. £10 million has been spent on Operation Northmoor, which is the RMP's investigation into 675 allegations from Afghanistan. At their height, the Iraq Historical Allegations Team and Operation Northmoor each involved over 100 investigators who have collated and reviewed vast numbers of documents and have interviewed large numbers of alleged victims, families, witnesses, service personnel and veterans. Throughout, the MOD has wanted investigations and prosecution decisions to be conducted efficiently and effectively, but the reality is that the nature of warfare has changed. So-called lawfare has become a tool for extending conflicts by other means or attempting to actually rewrite history itself. Please do.
If I could take him back just slightly, because the investigators that he mentions at the dispatch box who looked at many of these allegations, these are the same people who have now blown the whistle to the BBC and the Sunday Times. These are the same people who've come forward and who've said that things have been shut down. So can I ask him that by the time he says he's going to bring forward this primary legislation in the near future, does he envisage there will be greater resource or less resource to investigate as a result of his legislation?
Let me be very clear with my honourable friend. There have been allegations made by individuals, some of whom worked within the investigative teams, a very small number. There have been allegations made by a small number of people associated with operational units involved in these incidents that have been alleged. And they have made allegations, and investigators who have interviewed them have been persuaded by their case. Those allegations are then investigated and presented to an independent service prosecuting authority, who then make a decision as to whether or not that threshold of evidence has been breached and that a conviction or even a prosecution is likely. And that decision has been made in a clear-eyed, professional manner, without fear or favour, in order to bring this matter to a close. It is in nobody's interest that this has continued as long as it has. In terms of resource as to what's going to happen, I'll come on to my thoughts as to how we address this going forward, and I'll address that towards the end of my remarks, but please do pick me up if I don't. In the case of Iraq, the investigative challenges were compounded by the behaviour of some of the legal firms involved. Public interest lawyers firm waged a long-running campaign challenging the ability of the service police to conduct independent and effective investigations. Having lost that argument, PIL notified approximately 1,200 new allegations, many of which were found upon examination to be seriously misplaced or extremely flimsy. Now, I am clear. The IHAC could have handled matters much better. I have not changed my view on that since I personally ran the campaign to expose its practices, but I want to make it absolutely clear that there has been no strategic interference whatsoever in individual cases or in the overall Iraq or Afghanistan caseloads. It would be completely pointless. Allegations that are not fully investigated will only contrive to extend the process for our servicemen and women. All investigative and prosecution decisions have been made independently by the Service Police and the Service Prosecuting Authority without reference to the MOD or the chain of command or ministers. They have also been subject to independent external and to periodic independent reviews by subject matter experts. The Iraq investigations have been subject to an unprecedented court oversight, with extensive transparent reporting obligations to a designated judge of the High Court. Operation Northmoor has been subject to an independent assurance by an experienced senior criminal barrister and a retired chief constable. So the allegation that IHAT and Northmoor investigations were closed down for political reasons in 2017, I'm afraid, is simply wrong and self-defeating. The IHAT's caseload was transferred to the SPLI, which stood up on the 1st of July in 2017, and is still conducting a small number of investigations. Investigations under Operation Northmoor continued with independent external assurance into 2019, last year. The assertion that the Ministry of Defence exploited the taint that resulted from Phil Shiner's misconduct to close investigations is also incorrect. The evidence that PIL had paid an undisclosed number of Iraqis, apparently by way of inducement to bring allegations against our armed forces, only emerged after the IHAT and Service Prosecuting Authority has started reviewing the Iraq caseload to decide, in accordance with the High Court's direction, whether further investigation was warranted in individual cases. The IHAT and SPA informed the High Court of their approach and the rationale for it. The High Court did not express any concern about this review process. None of the investigations under Op Northmoor were affected by Phil Shiner being struck off, as the BBC and Sunday Times assert, because none of the investigations involved were actually notified by Phil Shiner. Mr. Speaker, the Sunday Times and the BBC assert that the closure of IHAT was intended to ensure the alleged war crimes in Iraq went unpunished. I have outlined why this is simply not credible to the UK's armed forces as an institution that prides itself on its ethos and values that set it apart from this nation's enemies. But factually, they cite two cases in support of this wholly untenable position: the shooting of an off-duty Iraqi policeman and the deaths of Radi Nama and Abdul Jabbar Musa Ali at Camp Stephen. In fact, both cases were taken over by the SPLI when the IHAT closed. The SPLI's investigations into both cases only finished in early 2019. This means that the information that formed the basis of comments by former IHAT investigators and by Lord MacDonald, whom my honourable friend refers to, was incomplete and at least 2 years out of date. Whilst it has not been possible to attribute the deaths of Mr Nama and Mr Musa Ali to any individuals, SPLI referred 3 people to the Service Prosecuting Authority for having committed or failed to prevent, punish or report outrages upon personal dignity. In coming to a decision in this case, the Director of Service Prosecutions obtained legal independent advice from senior external counsel. Mr Speaker, it is a matter of deep personal regret that the original RMP investigations were flawed and that opportunities to hold those responsible to account may now have been lost. For this, I unreservedly apologise to those who suffered treatment at the hands of UK forces that was simply unacceptable. And I apologise to our servicemen and women who have, as a result, had years of investigations foisted upon them, having more often than not had nothing to do with the incidents in question. As the Al-Swedi inquiry has already highlighted, the RMP elements deployed to Iraq were simply insufficient to cope with the unexpectedly high number of incidents requiring investigation. This is what led to the Provost Marshal Army in 2010 to direct the IHAT to review 9 RMP investigations, including those into the deaths of Mr Nama and Mr Musa Ali, to ascertain whether all lines of inquiry had been followed. The considerable obstacles to obtaining sufficient evidence to prosecute in historical cases have been recognised by the High Court, which in 2013 ordered the MOD to establish a process of non-criminal quasi-inquests, which have become known as Iraq fatality investigations, in order to satisfy fully our obligations under the European Convention on Human Rights. These IFIs are similar in form to a coroner's inquest and are conducted by an independent retired judge. They are designed to provide the families of the deceased with answers and to help the armed forces learn lessons for the future. Whilst the fact that the 2003 report into Mr. al-Musawi's death contains inaccurate information is deeply concerning, there is insufficient evidence to refer anyone for offence in relation to this incident. Having exhausted all reasonable and proportionate lines of inquiry, SPLI have uncovered no evidence that conclusively refutes the soldier's assertion that he acted in self-defence. Indeed, 2 of the deceased brothers told investigations that Mr. al-Musawi fired several shots into the air immediately prior to this shooting. So in conclusion, Mr. Speaker, today's debate and previous debates on historical investigations have shown the strength of feeling there is on this vital issue. I am considering some key policy interventions to learn lessons from over 15 years of investigations and litigation arising from operations in Iraq and Afghanistan. I am not of the opinion that any organisation the size of the UK's armed forces will not have their challenging individuals. There is no doubt that some of the experiences of those who came into contact with the UK's armed forces in Iraq and Afghanistan were completely unacceptable.
The Minister is about to close. Can I take him back, because he did ask me to remind him? Does he think that after he brings his legislation forward, there will be greater resource to investigate these affairs or not? And in addition to that, is the Royal Military Police, in his view, in its current form, fit for purpose?
So what I'll say to my honourable gentleman is that, in my view, no option is off the table in terms of reflecting over the last 15 years as to how we never end up in this position again. And in terms of resource in this investigation has not been a determining factor. There's over £50 million that's gone into investigating these crimes in both Iraq or alleged crimes in Iraq and Afghanistan. But I will, of course, this is not going to be some sort of paper exercise. This is a defining issue for many of us. We will, of course, do this properly. There is I hope he will have seen from my comments this evening, there is absolutely no intention to cover anything up, to let anybody who sees uniform as a place where you can commit crimes, to enable any of that behaviour, which is totally out of kilter with 99% of people's experiences in the military. But I am equally firm that the experience of too many of those who have served this nation in operations in subsequent years has been totally unacceptable. And in that respect, this Prime Minister and this government is going to redefine the debate. Of course.
Minister for giving way, and he's making an excellent point. And for those, and I declare an interest at the start of my comment in that my husband is a veteran himself from Remy, that for those who have been subject to investigation after investigation, are we providing enough psychological support and support in terms of their mental health? Because no matter the circumstances, one can't but help think that this must be a very stressful situation for themselves and their families, and that as much as possible must be done.
I thank my honourable friend for her intervention, and I would restate that the experience of some of our finest people has been completely unacceptable, and I speak to the process that they have been subjected to, and I speak to the way my department has looked after them through that process. I think that certainly since 2015 or 2016, when a few of us started working on this, that has now, I have satisfied.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. I'm sorry to have to interrupt the Minister, but the Minister.
I am now confident, having interrogated these processes, that we are now in a much better place to support these individuals. There are challenges in reaching out to those who served over a longer period of time ago. But again, we are acutely aware of those challenges. And again, the MOD exists now to support in provision of legal costs, in provision of pastoral care, in getting these individuals through what is a very, very difficult situation. But finally, Mr. Speaker, a key function of a modern military force is the ability to document and evidence sensitive operations in a highly complex and challenging battle space. We expect a relentless pursuit of excellence in all our armed forces, particularly in the specialist units involved in these allegations. If we are to manufacture the political space to introduce increased levels of legal protections for our armed forces going forward, I am very conscious that we must demonstrate the ability to hold our people firmly to account, and this has not always been the case. But I hope tonight the House and the country will have noted my determination to get this right. Those who break the law will and must be held to account where the evidence exists, and that evidential point is paramount. We cannot do so without evidence that breaches the thresholds required for prosecutions. But I am equally firm that this government will simply not allow our legal processes to be exploited in an attempt to hound servicemen and women or rewrite history. Most fair-minded men and women in this country understand that war is a supremely chaotic, dangerous, frightening and confused environment. This is not a cover for criminal behaviour. In fact, it is a tribute to the incredible standards and sacrifices of our armed forces, which I again pay tribute to tonight. But uniform is no place for those who cannot operate within the boundaries we ask them to, and that is a view you will find most strongly shared by those who make up that community.
The question is that this House do now adjourn. As many of that opinion say aye? Aye. The ayes have it. Order, order.